Live from the BDN Studios, it's Bang and Dang.
That's awesome.
If you don't like that, then
You ain't black.
All right, welcome back to Battles, Americans of War, Behind the Battles. This week, we're really going behind the battles. It's not even Civil War, but considered one of the things that led up to the Civil War.
Dred Scott, Marty.
The old Dred Scott versus Sandford court case.
You guys know this.
Where the U.S. Constitution, the Supreme Court said the U.S. Constitution does not extend American citizenship to people of black African descent. And therefore, they have no rights and privileges that regular Americans had. White people.
Right. They're not considered as...
They're not a people. They're a property.
Yep.
This decision apparently is held widely considered the worst in the Supreme Court's history, which obviously denounced for racism, judicial activism, poor legal reasoning, and crucial role leading up to the events that caused the Civil War 4 years later. Yeah. When you rule somebody's a property... They have no rights.
And this is another reason why I always say the Civil Wars wasn't fought over slavery, because the North loved this rule too. Everybody did. They didn't want to see blacks as a human, as a regular human being. They weren't treated that way.
In the late 1810s, a major political dispute arose over the creation of new U.S. states from the vast territory the United States had acquired from France in the Louisiana Purchase in 1803.
That was a steal.
The dispute centered on whether the new states would be free, in which slavery would be illegal, or whether they would be slave, which would be legal, obviously, North and South. Southern states wanted the new states to be slave states in order to enhance their own political and economic power. Northern states obviously wanted the new states to be free for their own political and economic reasons, as well as their moral concerns over allowing the institution of slavery to expand. I guess they didn't mind slavery. They just didn't want it to go everywhere else.
Right. They're like, that's enough where we got it. They were all willing to keep it in the South
Obviously.
and east of the Mississippi.
Abraham Lincoln.
In 1820, the United States Congress passed legislation known as the Missouri Compromise that was intended to resolve the dispute. But did it?
Compromise or do anything.
Right. The compromise first admitted Maine into the Union as a free state, then created Missouri out of a portion of the Louisiana Purchase territory and admitted it as a slave state. It also prohibited slavery in the area north of the parallel 36 degree by 30 north, where most of the territory lay.
Right. They were like, the majority of this Louisiana Purchase is all north of that, so it should be good, right, Southerners?
Right. The legal effects of slave owner taking his slaves from Missouri into the free territory north of the 36 degree 30th north parallel, as well as the constitutionality of the Missouri Compromise itself, it eventually came to a head in the Dred Scott case.
Yeah. That's what it was all about. Dude tried taking his slave into a non-slave state, and they were like, no, you're sorry, Dred. Well, as for Dred, he was born a slave in Virginia around 1799. Little is known of his early years, clearly. His owner, Peter Blow, moved to Alabama in 1818, taking his 6 slaves along to work a farm near Huntsville. In 1830, Blow gave up farming and settled in St. Louis, Missouri, where he sold Scott to U.S. Army surgeon Dr. John Emerson.
Okay.
After purchasing Scott, Emerson took him to Fort Armstrong in Illinois, which we know that was a free state, and it had been free as a territory under the Northwest Ordinance of 1787.
Nice.
And prohibited slavery in its constitution in 1819 when it was admitted as a state.
Well, in 1836, Emerson, he moved with Scott from Illinois to Fort Snelling in the Wisconsin Territory, in what has become the state of Minnesota. Slavery in the Wisconsin Territory, some of which, including Fort Snelling, was part of the Louisiana Purchase. It was prohibited by the United States Congress under the Missouri Compromise, obviously. During his stay at Fort Snelling, Scott married Harriet Robinson in a civil ceremony by Harriet's owner, Major Lawrence Taliaferro, a justice of the peace, who was also an Indian agent. The ceremony would have been unnecessary had Dred Scott been a slave, as slave marriages had no recognition in the law.
Oh, so we got a little preamble here. Why have a ceremony if it didn't need it?
Well, because they're in a free state.
Well, it doesn't matter. You're still a slave.
Right.
Well, in 1837, the Army ordered Emerson to Jefferson Barracks military post south of St. Louis. Emerson left Scott and his wife at Fort Snelling, where he leased their services out for profit. By hiring Scott out in a free state, Emerson was effectively bringing the institution of slavery into a free state.
Well, not really.
Which was a direct violation of the Missouri Compromise, the Northwest Ordinance, and the Wisconsin Enabling Act.
Well, I guess it would be because that guy's getting paid, not the slave.
Or the slave owner.
The slave owner's getting paid.
But
not the slave.
To do work in the, not under him, but for somebody else.
Before the end of the year, the Army reassigned Emerson to Fort Jessup in Louisiana, where Emerson married Eliza Irene Sandford in February of 1838. Emerson sent for Scott and Harriet, who proceeded to Louisiana to serve their master and his wife. Within months, Emerson was transferred back to Fort Snelling. What is this bullshit? While en route to Fort Snelling, Scott's daughter Eliza was born on a steamboat underway on the Mississippi River between Illinois and what would become Iowa.
Oh, look at that. She's not a slave.
Oh, wow. Because Eliza was born in the free territory, she was technically born as a free person under both federal and state laws. Good for you, Eliza.
All right. Well, upon entering Louisiana, the Scots could have sued for their freedom, but did not. One scholar suggests that in all likelihood, the Scots would have been granted their freedom by a Louisiana court, as they had respected laws of free states that slaveholders forfeited their right to slaves if they brought them in for extended periods.
Right.
This had been the holding in Louisiana state courts for more than 20 years, and that was Louisiana it was happening.
Well, I got a feeling these guys were like family to them, kind of.
Well, you sure about that?
Well, I don't know. If they didn't want to sue. Toward the end of 1838, the Army reassigned Emerson back to Fort Snelling. By 1840, Emerson's wife Irene returned to St. Louis with their slaves, while Dr. Emerson served in the Seminole War.
No.
While in St. Louis, she hired them out again.
Oh, no.
In 1842, Emerson, he said, "I'm done with you, Army. I'm going home." After he died in the Iowa Territory in 1843. He left the Army just to die in the Iowa Territory. Son of a bitch. His widow Irene inherited his estate, including the Scots. For 3 years after John Emerson's death, she continued to lease out the Scots as hired slaves. 1846, Scott attempted to purchase his and his family's freedom, but Irene Emerson refused because they were making him so much money. This prompted Scott to resort to legal recourse. He's like, all right, I want to be nice.
When been unsuccessful in his attempt to purchase his freedom, Scott, with the help of his legal advisors, sued Emerson for his freedom in the Circuit Court in St. Louis County, April 6, 1846. A separate petition was filed for his wife Harriet, making them the first married couple to file freedom suits in tandem in its 50-year history.
Nice.
They received financial assistance from the family of Dred's previous owner, Peter Blow.
Whoa. All right.
Blow's daughter, Charlotte, was married to Joseph Charles with 2 S's, an officer at the Bank of Missouri. Oh, getting all that money.
Oh.
Charles signed legal documents as security for the Scots and later secured the services of the bank's attorney, Samuel Mansford Bay, for the trial. Wow, look at these guys, dude.
Okay. It was expected that the Scots would win their freedom with relative ease. By 1846, dozens of freedom suits had been won in Missouri by former slaves. Most had claimed their legal right to freedom on the basis that they or their mothers had previously lived in free states or territories. Among the most important legal precedents were Winnie versus Whitesides and Rachel versus Walker.
It's funny, they just used their first name because they have no last name.
In Winnie versus Whitesides, the Missouri Supreme Court had ruled in 1824 that a person who had been held as a slave in Illinois, where slavery was illegal, and then brought to Missouri, was free by virtue of residence in a free state.
Okay. Well, Rachel V. Walker, the state Supreme Court, had ruled that a U.S. Army officer who took a slave to a military post in a territory where slavery was prohibited and retained her there for several years had thereby forfeited his property.
Oh.
Rachel, like Dred Scott, had accompanied his enslaver to Fort Snelling.
Okay.
Her enslaver. Scott was represented by 3 different lawyers from the filing of the original petition to the time of the actual trial, which was over 1 year later. The first was Francis B. Murdoch, a prolific freedom suit attorney who abruptly left St. Louis. He set him out. They probably threatened him.
Right. Yeah. Well, after Murdoch left, he was replaced by Charles D. Drake. He was an in-law of the Blow family. When Drake also left the state.
What the hell?
Well, Drake, he left the state as well. Samuel M. Bay, he said, I'm going to take over. Come on, Scots, I'm going to be your lawyer. Irene Emerson was represented by George Good, a pro-slavery lawyer from Virginia. By the time the case went to trial, it had been reassigned from Judge John Crum, who was pro-slavery, to a Judge Alexander Hamilton, who was known to be sympathetic to freedom suits.
Things are looking good for old Scots, huh?
Right.
Well, Dred Scott versus Irene Emerson finally went to trial for the first time June 30th, 1847. Henry Peter Blow, he testified in court that his father had owned Dred and sold him to John Emerson. Right. The fact that Scott had been taken to live on free soil was clearly established through depositions from witnesses who had known that Scott and Dr. Emerson were at Fort Armstrong and Fort Snelling. And the Army could attest to this, I would assume.
Very easy.
Grocer Samuel Russell, he testified that he had hired the Scotts from Irene Emerson and paid her father, Alexander Sandford, for their services.
Oh, I mean, come on, that's plenty enough. End it right now.
Right.
Well, upon cross-examination, however, Russell admitted that the leasing arrangements had actually been made by his wife, Adeline.
Who gives a shit?
Thus, Russell's testimony was ruled hearsay.
Oh.
And the jury returned a verdict for Emerson.
That's bullshit. How's that hearsay?
Right. This created a seemingly contradictory outcome in which Scott was ordered by the court to remain Irene Emerson's slave because he had been unable to prove that he was previously Irene Emerson's slave. Oh, everything's right there. Get the fuck out of here.
How is he unable to prove that he was previously Irene Emerson's slave when she was the husband? Her husband was clearly Emerson, and when he died, he clearly left his estate to her.
Oh, I can't believe that. That's insane.
Wow. Well, Bay moved immediately for a new trial on the basis that Scott's case had been lost due to a technicality which could be rectified rather than facts.
Right.
Judge Hamilton finally issued the order for a new trial December 2nd, 1847. 2 days later, Emerson's lawyer objected to a new trial by filing a bill of exceptions. The case was then taken on writ of error to the Supreme Court of Missouri.
Ooh, all right. Let's see what these bastards have to say.
Well, we know what they said.
Well, Scott's new lawyers, Alexander P. Field and David N. Hall, they argued that the writ of error was inappropriate because the lower court had not yet issued a final judgment. Oh. The state Supreme Court agreed unanimously that with their position and dismissed Emerson's appeal on June 30th, 1848. Ooh, bring it to trial, baby. The main issue before the court at this stage.
So is he still slaving for these people through this whole thing?
Yep.
That's crazy.
Wow. The main issue before the court at this stage was procedural and no substantive issues were discussed.
Well, before the state Supreme Court had convened, good. He had presented a motion on behalf of Emerson to have Scott taken into custody and hired out again. Said, well, we're doing this. Yeah, answer my question. Huh? March 17th, 1848, Judge Hamilton issued the order to the St. Louis County Sheriff. Anyone hiring Scott had to post a bond of $600.
Oh.
Wages he earned during that time were placed in escrow to be paid to the party that prevailed in the lawsuit.
Oh,
nice.
I like it.
Scott, he would remain in the sheriff's custody or hired out by him until March 18th, 1857. One of Scott's lawyers, David Hall, hired him starting March 17th, 1849. Good for you, bud.
All right.
1857?
That's insane.
Good Lord.
Oh, my.
He probably said, here, bud, we'll hire you. Maybe he made him do some paperwork or some shit.
Right, not even nothing. The St. Louis fire of 1849 and also a cholera epidemic and 2 continuances delayed the retrial in the St. Louis Circuit Court until January 12th, 1850. Irene Emerson was now defended by Hugh Garland and Lyman Norris, while Scott was represented by Field and Hall.
Good for you keeping your same lawyers for once.
Right. Judge Alexander Hamilton was presiding. The proceedings were similar to the first trial. The same depositions from Catherine A. Anderson and Miles H. Clark were used to establish that Dr. Emerson had taken Scott to a free territory.
This time, the hearsay problem was surmounted by a deposition from Adeline Russell, stating that she had hired the Scotts from Irene Emerson. So there's that. Proving that Emerson claimed them as her slaves. Samuel Russell testified in court once again that he had paid for their services. The defense then changed strategy and argued in their summation that Mrs. Emerson had every right to hire out Dred Scott because he had lived with Dr. Emerson at Fort Armstrong and Fort Snelling under military jurisdiction, not under civil law.
Doesn't matter. The law done says if you had a...
But regardless, she just admitted that he hired him out.
Right.
She hired him out.
Wow. Well, in doing so, the defense ignored the precedent sent by Rachel V. Walker.
Right.
In his rebuttal, Hall stated that the fact that they were military posts did not matter. And that pointed out that Dr. Emerson had left Scott behind at Fort Snelling, hired out to others after being reassigned to a new post. The jury was like, what? They started chatting back for
Order! I'll hold you all in contempt.
I hold myself in contempt. The jury quickly returned a verdict in favor of Dred Scott.
Oh, damn sure.
Damn right.
We know it don't end in there, though.
Oh, nominally making him a free man. Judge Hamilton declared Harriet, Eliza, and Lizzie Scott to be free as well.
Oh, there's got another kid, huh?
Oh. Garland moved immediately for a new trial. It was overruled.
Overruled? So it should be done and over with.
Right.
Well, it's not, because February 13th, 1850,
Holy
Emerson's
shit.
defense filed a bill of exceptions, which was certified by Judge Hamilton.
This bitch, dude. She lost. Get it over with. It's a fucking human being. Let him go.
Are they that valuable? They must have made a lot of money for her.
Jeez.
That set into motion another appeal to the Missouri Supreme Court. Counsel for the opposing side signed an agreement that moving forward, only Dred Scott versus Irene Emerson would be advanced.
Oh.
That any decision made by the High Court would apply to Harriet's suit also.
Oh.
So in his case, she's
Right.
built in.
It's one and done, baby.
Right. In 1849 or 50, Irene Emerson left St. Louis and moved to Springfield, Massachusetts. Her brother, John F.A. Sandford, continued looking after her business interests when she left, and her departure had no impact on the case.
Oh, that. It should.
I would guess that's why it's called Scott versus Sandford instead of Emerson now.
Goodness, wow. Both parties filed briefs with the Supreme Court in Missouri on the 8th of March, 1850. A busy docket delayed consideration of the case until October. By then, the issue of slavery had become politically charged even within the judiciary. Oh. Although the Missouri Supreme Court had not yet overturned precedent in the freedom suits, in the 1840s, the court's pro-slavery justices had explicitly stated their opposition to freeing slaves. So, just can't see doing it. After the court convened on the 25th of October, 1850, the two justices were pro-slavery, anti-Benton Democrats, William Barclay Napton and James Harvey Birch. They persuaded John Ferguson Ryland, a Benton Democrat, to join them in a unanimous decision that Dred Scott remained a slave under Missouri law.
However, Judge Napton delayed writing the court's opinion for months. Then in August of 1851, both Napton and Birch lost their seats in the Supreme Court, following the state's first Supreme Court election with only Ryland remaining. The case thus needed to be considered again by the newly elected court. The reorganized Supreme Court now included two moderates, Hamilton Gamble and John Ryland, and one staunch pro-slavery Justice William Scott. So got the potential of 2-1 here.
Okay. David N. Hall had prepared the brief for Dred Scott, but died in March of 1851. So Alexander P. Field continued alone as counsel for Dred Scott, and he resubmitted the same briefs from 1850 for both sides. Then on the 29th of November 1851, the case was taken under consideration on written briefs alone, and a decision was reached. However, before Judge Scott could even write the court's opinion, Lyman Norris, co-counsel for Irene Emerson, obtained permission to submit a new brief he had been preparing to replace the original one submitted by Garland. I don't know if you can do that, can you? Norris's brief has been characterized as a sweeping denunciation of the authority of both the Northwest Ordinance of 1787 and the Missouri Compromise.
Although he stopped short of questioning their constitutionality, Norris questioned their applicability and criticized the early Missouri Supreme Court, ridiculing former Justice George Tompkins as the great apostle of freedom of that day. Reviewing the court's past decision on freedom suits, Norris acknowledged that if Rachel V. Walker was allowed to stand, his client would lose. Norris then challenged the concept of once free, always free, and asserted that the court under Tompkins had been wrong to rule that the Ordinance of 1787 remained in force after the ratification of the U.S. Constitution in 1788.
Finally, he argued that the Missouri Compromise should be disregarded whenever it interfered with Missouri law, and that the laws of other states should not be enforced if their enforcement would cause Missouri citizens to lose their property.
Don't bring them to places they're not supposed to go then.
Yep. In support of his argument, he cited Chief Justice Roger Taney's opinion in the United States Supreme Court case Strader versus Graham, which argued that the status of a slave returning from a free state must be determined by the slave state itself. According to historian Walter Ehrlich, the closing of Norris's brief was a racist harangue that not only revealed the prejudices of this author, but it also indicated how the Dred Scott case had become a vehicle for the expression of such views. He's like, it's just a shit show.
Right. Noting that Norris's pro-slavery doctrines were later incorporated into the court's final decision, Ehrlich writes, from this point on, the Dred Scott case clearly changed from a genuine freedom suit to the controversial political issue for which it became infamous in American history.
Oh, man.
March 22nd, 1852, Judge William Scott, he announced the decision of the Missouri Supreme Court that Dred Scott remained a slave and ordered the trial court's judgment to be reversed. Judge Ryland concurred, while Chief Justice Hamilton Gamble dissented.
Wow. The majority opinion written by Judge Scott focused on the issue of comedy over conflict of laws and relied on states' rights rhetoric. Well, there's some states' rights. And it said, every state has the right.
its rights.
Right. Every state has the right of determining how far, in a spirit of comedy, it will respect the laws of other states.
Right.
Those laws have no intrinsic right to be enforced beyond the limits of the state for which they were enacted. The respect allowed them will depend altogether on their conformity to the policy of our institutions. No state is bound to carry into effect enactments conceived in a spirit hostile to that which pervades her own laws. Dred Scott did not deny the constitutionality of the Missouri Compromise, and he also acknowledged that its prohibition of slavery was absolute, but only within the specified territory. Thus, a slave crossing the border could obtain his freedom, but only within the court of the free state.
But because they're in the court of a non-slave or a slave state, man.
Rejecting the court's own precedent, Scott argued that once free did not necessarily mean always free.
He then cited the Kentucky Court of Appeals decision in Graham versus Strader, which had held that a Kentucky slave owner who permitted a slave to go to Ohio temporarily, he didn't forfeit ownership of the slave. To justify overturning 3 decades of precedent, Dred Scott argued that circumstances had changed. He said, times now are not as they were when the former decisions on this subject were made. Doesn't matter, it's precedent.
Yep.
Since then, not only individuals, but states have been possessed with a dark and fell spirit in relation to slavery, whose gratification is sought in the pursuit of measures whose inevitable consequence must be the overthrow and destruction of our government. Under such circumstances, it does not behoove the state of Missouri to show the least countenance to any measure which might gratify this spirit. She is willing to assume her full responsibility for the existence of slavery within her limits, nor does she seek to share or divide it with others. So what goes on in Missouri stays in Missouri.
Right. Wow. On 23rd of March, 1852, the day after the Missouri Supreme Court decision had been announced, Irene Emerson's lawyers filed an order in the St. Louis Circuit Court for the bond signed by the Blow family to cover the Scott's court cost. Oh, what a piece of shit. Return of the slaves themselves and transfer of their wages earned over 4 years, plus 6% interest. On 29th of June, 1852, Judge Hamilton overruled that order.
Right, because they still got options in court.
Right.
The case looked hopeless, and the Blow family could no longer pay for Scott's legal costs.
Yeah, they're like, I'm sorry, bud.
Scott, he also lost both of his lawyers when Alexander Field moved to Louisiana and David Hall died, like we said. The case was then undertaken pro bono, which means free, by Roswell Field.
Well, that's a hell of a name.
Yeah, it was taken by Roswell Field, who employed Scott as a janitor.
Oh, fantastic.
Field also discussed the case with LeBaume, who had taken over the lease on the Scotts in 1851. After the Missouri Supreme Court decision, Judge Hamilton turned down a request by Emerson's lawyer to release the rent payments from escrow and to deliver the slaves into their owner's custody. He said, it ain't over yet. But
nope. 1853, Dred Scott again sued his current owner, John Sandford, but this time in federal court. Sandford returned to New York, and the federal courts had diversity jurisdiction under Article 3, Section 2 of the United States Constitution. In addition to the existing complaints, Scott alleged that Sandford had assaulted his family, probably did, and held them captive for 6 hours on New Year's Day of 1853.
Jeez.
At trial in 1854, Judge Robert Williams Wells, he directed the jury to rely on the Missouri law on the question of Scott's freedom. Since the Missouri Supreme Court had held that Scott remained a slave, the jury found in favor of Sandford. Well, that's bullshit.
Well, guess what? Scott's then going to go to the final frontier.
Yeah, his last chance.
He's going to appeal to the U.S. Supreme Court, where the clerk misspelled the defendant's name, and the case was recorded as Dred Scott versus Sandford, not Sanford.
Oh, no, they did it on purpose.
With an ever-erroneous title. Scott was represented before the Supreme Court by Montgomery Blair and George Ticknor Curtis, whose brother Benjamin was a Supreme Court justice. Sandford was represented by Reverdy Johnson and Henry Geyer.
Okay. Well, when the case was finally filed, the two sides agreed on a statement of facts that claimed Scott had been sold by Dr. Emerson to John Sandford, though this was a legal fiction.
Right. He only took over his sister's shit, not even legally, I don't think.
Dr. Emerson had died in 1843, who originally owned Scott, and Dred Scott had filed his 1847 suit against Irene Emerson.
Mm-hmm.
There was no record of Dred Scott's transfer to Sandford or of his transfer back to Irene. John Sandford died shortly before Scott's manumission. And Scott was not listed in the probate records of Sandford's estate.
Oh, so there you go.
So that's instantly, it's over with.
Jeez. Also, Sandford was not acting as Dr. Emerson's executor, as he was never appointed by a probate court.
So how did they even get to go to all these courts? Oh, my.
And the Emerson estate had been settled when the federal case was filed. The murky circumstances of ownership led many to conclude the parties to Dred Scott versus Sandford contrived to create a test case.
Right.
Oh, so yeah. Mrs. Emerson's remarriage to abolitionist U.S. Representative Calvin Chaffee seemed suspicious to contemporaries, and Sandford was thought to be a front and to have allowed himself to be sued despite not actually being Scott's owner.
Of course it was. I mean, it all makes... Wow.
She's married to an abolitionist?
Wow. Nevertheless, Sandford had been involved in the case since 1847, before his sister married Chaffee. He had secured counsel for his sister in the state case, and he engaged the same lawyer for his own defense in the federal case. Sandford also consented to being represented by genuine pro-slavery advocates before the Supreme Court, rather than to put up a token defense. I don't understand how this is even all possible.
Historians afterwards apparently discovered that after the Supreme Court heard arguments in the case, but before it issued a ruling, President-elect James Buchanan wrote to his friend, Supreme Court Associate Justice John Catrone, to ask whether the case would be decided by the court before his inauguration, March of 1857. Buchanan hoped that the decision would quell unrest in the country over the slavery issue by issuing a ruling to take it out of political debate. Then the only ruling would be let him free.
Yep.
He later successfully pressured Associate Justice Robert Cooper Grier, a Northerner, to join the Southern majority in the case to prevent the appearance that the decision was made along sectional lines.
Oh, according to historian Paul Finkelman, Buchanan already knew what the court was going to decide. In a major breach of court etiquette, Justice Grier, who, like Buchanan, was from Pennsylvania, he had kept the president-elect fully informed about the progress of the case and the eternal debates within the court. When Buchanan urged the nation to support the decision, he already knew that Taney would say, Republican suspicions of impropriety turned out to be fully justified.
Right, they did. Biographer Gene H. Baker argues that Buchanan's use of political pressure on a member of a sitting court was regarded then, as now, to be highly improper. Republicans fueled speculation as to Buchanan's influence by publicizing that Taney had secretly informed Buchanan of the decision. Buchanan declared in his inaugural address that the slavery question would be speedily and finally settled by the Supreme Court.
Would it? On the 6th of March, 1857, 8 long years. 8 long years. That's insane. The United States Supreme Court ruled against Dred Scott in a 7-2 decision that fills over 200 pages in United States reports. The decision contains opinions from all 9 justices, but the majority opinion has always been the focus of controversy. Wow.
It is.
Denied them,
7 justices formed the majority and joined an opinion written by Chief Justice Roger Taney. Taney began the court's opinion with what he saw as a core issue in the case: whether black people could possess federal citizenship under the U.S. Constitution. The question is simply this: can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all of the rights, privileges, and immunities guaranteed by that instrument to be citizen? And that is in...
Well, in answer, the court ruled they could not. It held that black people could not be United States citizens, and therefore a lawsuit to which they were a party could never qualify for the diversity of citizenship that Article 3 of the Constitution requires for a federal court to have jurisdiction over a case that does not involve a question of federal law. Sorry, bud. All that stuff, not going to work. And Dred Scott goes on.
The primary rationale for the court's ruling was Taney's assertion that the black African slaves and their descendants were never intended to be part of American social and political community. He says, "We think that they are not included, and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. On the contrary, they were at that time of America's founding considered as a subordinate, an inferior class of beings who had been subjugated by the dominant race, and whether emancipated or not, yet remained subject to their authority, and had no rights or privileges but such as those who held the power and government, and the government might choose to grant them."
No.
Jeez, dude.
Wow. Well, the court then extensively reviewed laws from the original American states that involved the status of black Americans at the time of the Constitution's drafting in 1787. Well, you can't do that.
Why? The question or not is in the Constitution.
It concluded that these laws show that a perpetual and impassable barrier was intended to be erected between the white race and one which they had reduced to slavery. And the one, they can't even say what kind of race that was. The court therefore ruled that black people of all shapes and sizes were not American citizens, and they could not even sue as citizens in federal courts. Like, I don't even know why we're even doing this case.
Well, this meant that U.S. states lacked the power to alter the legal status of black people by granting them state citizenship. It is difficult at this day to realize the state of public opinion in relation to that unfortunate race, which prevailed in the civilized and enlightened portions of the world at the time of the Declaration of Independence and when the Constitution of the United States was framed and adopted. They had for more than a century before been regarded as beings of an inferior color, of an inferior order, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. Yeah. Wow, guys.
Wow. That's some crazy shit right there, I'll tell you what. This holding normally would have ended the decision, since it disposed of Dred Scott's case by effectively declaring that Scott had no standing to even bring the suit. Like, what? I don't even understand. Why are we even taking this case? But Taney, he did not even confine his ruling to the matter immediately before the court. He went on to assess the constitutionality of the Missouri Compromise itself, writing that the compromise's legal provisions intended to free slaves who were living north of the 36th north and 30th degree latitude in the Western Territories. In the court's judgment, this constituted the government depriving owners of slave property without due process of law, which is forbidden under the Fifth Amendment.
Oh. Taney also reasoned that the Constitution and the Bill of Rights implicitly precluded any possibility of constitutional rights for black African slaves and their descendants. He concluded, now, the right of property in a slave is distinctly and expressly affirmed in the Constitution. Upon these considerations, it is the opinion of the court that the act of Congress, which prohibited a citizen from holding and owning property of this kind in the territory of the United States, north of the line therein mentioned, is not warranted by the Constitution and is therefore void.
Oh.
Those are lines 451 and 452 in the case.
Taney held that the Missouri Compromise was unconstitutional, marking the first time since the 1803 case, which was Marbury versus Madison, that the Supreme Court had struck down a federal law, although the Missouri Compromise had already been effectively overridden by the Kansas-Nebraska Act. Taney based his argument on a narrow interpretation of the Property Clause of Article 4, Section 3 of the Constitution, which stated, "The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States." ...
Well, he ruled that the property clause applied only to the property which the states held in common at that time and has no reference whatsoever to any territory or other property which the new sovereignty might afterwards itself acquire. Because the Louisiana Territory was not part of the United States at the time of the Constitution's ratification, Congress did not have the authority to ban slavery in the territory.
No.
Thus, the Missouri Compromise exceeded the scope of Congress's powers and was unconstitutional.
Yep.
And hence, Dred Scott was still a slave regardless of his residence in the purportedly free Northwest Territory.
Okay.
And he was still a slave under Missouri law, which had proper authority over the matter anyway. For all these reasons, the court concluded that Scott could not bring suit in a U.S. federal court.
I mean, if you go by the book of law, I guess. I mean, something has to be changed here. Wow. Justices Benjamin Robin Curtis and John McLean, they dissented from the court's decision, and they both authored dissenting opinions. Curtis's 67-page dissent argued that the court's conclusion that black people could not be citizens of the United States was legally and historically baseless. He pointed out that at the time of the Constitution's adoption in 1789, black men could vote in 5 of the 13 states. Oh, wow. Under the law that made them citizens of both their individual states and the United States of America. Curtis cited many state statutes and court decisions in support of his position. Oh, shit. Didn't know that.
His dissent was extremely persuasive, and it prompted Taney to delay issuing the decision for several weeks while he added 18 pages of rebuttal to the majority opinion.
Oh, wow.
McLean's dissent deemed the argument that black people could not be citizens more of a matter of taste than of law. He attacked much of the court's decision as non-binding obiter dicta, arguing that once the court determined that it did not have jurisdiction to hear Scott's case, it should have simply dismissed the action without passing judgment on the merits of Scott's lawsuit. Yeah. So you should have said, we can't hear it.
Right.
And not give your opinion like you just did. So now every other court in the land would have. Wow.
Oh, Curtis and McLean, they both attacked the court's overturning of the Missouri Compromise. They noted that it was not necessary to even decide the question, and that none of the authors of the Constitution had ever even raised constitutional objections to the anti-slavery provisions of the Northwest Ordinance, or the subsequent acts that barred slavery north of the 36 degree by 30 north parallel lines, or the prohibition on importing slaves from overseas passed in 1808.
Curtis, he said slavery was not listed in the Constitution as a natural right, but rather as a creation of public law. Article 4, Section 3 of the Constitution states, the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. No exception was made for slavery, which thus fell under the regulatory power of Congress.
Oh. All right. Well, the Supreme Court's decision in Dred Scott was greeted with widespread fury outside the slaveholding states. American political historian Robert G. McCloskey, his reaction was, where he described the reaction, the tempest of malediction that burst over the judges seems to have been stunned. Far from extinguishing the slavery controversy, they had fanned its flames and had, moreover, deeply endangered the security of the judicial arm of government. No such vilification as this had been heard, even in the wrathful days following the Alien and Sedition Acts. Taney's opinion was assailed by the Northern press as a wicked stump speech and was shamefully misquoted and distorted. If the people obey this decision, said one newspaper, they disobey God.
Oh, wow. Many Republicans, including Note Abe himself, who was rapidly becoming the leading Republican in Illinois and was elected president 3 years later, clearly. They regarded the decision as part of a plot to expand and eventually impose the legalization of slavery throughout all of the state. Some Southern extremists wanted all states to recognize slavery as a constitutional right. Lincoln rejected the court's majority opinion that the right of property in a slave is distinctly and expressly affirmed in the Constitution, pointing out that the Constitution did not ever refer to slaves as property, and in fact explicitly called them persons.
Wow.
Right. What were they? 1/16 of a person or something?
Yeah, that's crazy. Southern Democrats, they consider Republicans to be lawless rebels who were provoking disunion by the refusal to accept the Supreme Court's decision as law of the land. Many Northern opponents of slavery offered a legal argument for refusing to acknowledge the Dred Scott decision on the Missouri Compromise. They argued, following Justice Curtis's dissenting opinion, that the court's determination that the federal courts had no jurisdiction to hear the case rendered the remainder of the decision a non-binding obiter dictum, an advisement rather than an authoritative interpretation of the law. It's just an advising. He's like, well, this really ain't the law, but...
As you would think, Stephen Douglas, he also attacked that position in the Lincoln-Douglas debates. Mr. Lincoln, he says, goes for a warfare upon the Supreme Court of the United States because of their judicial decision in the Dred Scott case. I yield obedience to the decisions in that court, to the final determination of the highest judicial tribunal known to our Constitution. In a speech at Springfield, Illinois, Lincoln responded that the Republican Party was not seeking to defy the Supreme Court, but he hoped they would convince it to reverse its ruling. He says, we believe as much as Judge Douglas, perhaps more, in obedience to and respect for the judicial department of government. We think its decisions on constitutional questions, when fully settled, should control not only the particular cases decided, but the general policy of the country, subject to be disturbed only by amendment of the Constitution as provided in that instrument itself.
Right.
More than this would be revolution. But we think the Dred Scott decision is erroneous. We know the court that made it has often overruled its own decisions, and we shall do what we can to have it to overrule this. We offer no resistance to it, though.
Can't do anything about it. Democrats had previously refused to accept the court's interpretation of the United States Constitution as permanently binding. We still see that today. During the Andrew Jackson administration, Taney, he was then Attorney General, he'd written, whatever may be the force of the decision of the Supreme Court in binding the parties and settling their rights in the particular case before them, I'm not prepared to admit that a construction given to the Constitution by the Supreme Court in deciding any one or more cases fixes of itself irrevocably and permanently its construction in that particular, and it binds the states and the legislative and executive branches of the general government forever afterwards to conform to it and to adopt it in every other case as the true reading of the instrument, although all of them may unite in believing it's erroneous.
Doesn't matter if you think it is.
Right.
Frederick Douglass, he predicted that the decision would bring the conflict over slavery to a head. The highest authority has spoken. The voice of the Supreme Court has gone out over the troubled waves of the national conscience, but my hopes were never brighter than now. I have no fear that the national conscience will be put to sleep by such an open, glaring, and scandalous tissue of lies.
Yeah, he was right. Took a couple more years than now, but hey, according to Jefferson Davis,
He was like, lock him up!
he was a United States Senator at this point from Mississippi. The case merely presented the question whether Cuffy, which was a derogatory term for a black person,
Oh, we're allowed to say that?
wow, should be kept in his normal condition or not, and whether the Congress of the United States could decide what might or might not be property in a territory. The case being that of an officer of the army sent into a territory to perform his public duty, having taken with him his Negro slave. That's the case.
That is the case.
That is the case.
Irene Emerson, she moved to Massachusetts in 1850 and married Calvin Chaffee, a doctor and abolitionist who was elected to Congress on the Know-Nothing and Republican tickets. Following the Supreme Court ruling, pro-slavery newspapers attacked Chaffee as a hypocrite. Chaffee protested that Dred Scott belonged to his brother-in-law and that he had nothing to do with Scott's enslavement.
Oh.
Nevertheless, as a means of freeing Scott, the Chaffees executed a deed transferring the Scott family to Henry Taylor Blow, who was the son of Scott's former owner, who could appear in person before the Missouri court. Look at that.
Well, that's nice.
They're going to let him free?
Well, Taylor Blow, he had previously contributed to Scott's legal fees during the case as well. He filed the manumission papers with Judge Hamilton on 26th of May, 1857. The emancipation of Dred Scott and his family was national news, celebrated in northern cities. Scott worked as a porter in a hotel in St. Louis, where he was a minor celebrity. His wife took in laundry. Dred Scott died tuberculosis, 7th of November, 1858.
Oh, jeez.
Harriet died on June 17th, 1876. Damn, tuberculosis is killing him, huh? And he wanted to be free. He wanted to die a free man.
Crazy. Not even a year.
Jeez.
Economist Charles Calomaris and historian Larry Schweikart, they discovered that uncertainty about whether the entire West would suddenly become slave territory or engulfed in guerrilla conflict like Bleeding Kansas gripped the markets immediately. The east-west railroads became insolvent immediately,
Right.
although north-south lines were unaffected, in turn causing dangerous runs on several large banks, events known as the Panic of 1857.
This financial panic, unlike that of 1837, almost exclusively impacted the North, which the historians attributed to the North system of unit banking, with many competing banks hid financial information from one another, breeding uncertainty. They're like, oh, man. In contrast, the South branch banking system allowed information to move reliably among the branch banks, and transmission of the panic was very minor.
Man. Southerners who had grown uncomfortable with the Kansas-Nebraska Act, they argued that they had a constitutional right to bring slaves into the territories, regardless of any decision by a territorial legislature on the subject. The Dred Scott decision seemed to endorse that view. Although Taney believed that the decision represented a compromise that would be a final settlement of the slavery question by transforming a contested political issue into a matter of settled law, the decision produced quite the opposite result.
It strengthened Northern opposition to slavery, divided the Democratic Party on sectional lines, encouraged secessionist elements from Southern supporters of slavery to make bolder demands, and also strengthened the Republican Party. 1860, the Republican Party explicitly rejected the Dred Scott decision in their original platform.
Or official.
Right, stating that the new dogma that the Constitution of its own force carries slavery into any or all of the territories of the United States is a dangerous political hearsay at variance with the explicit provisions of that instrument itself, with contemporaneous exposition and with legislative and judicial precedent is revolutionary in its tendency and subversive of the peace and harmony of the country. These guys sure do write a lot of bullshit to say very little.
That we don't like it.
Right.
Jeez. 1859, when defending two black men, John Anthony Copeland and Shields Green, from the charge of treason they were defending them from, following their participation in John Brown's raid on Harper's Ferry. Their attorney, George Sennett, cited the Dred Scott decision and arguing successfully that since they were not citizens according to the Supreme Court ruling, they could not commit treason. Oh. Nevertheless, they were found guilty and executed on other charges.
Oh, really?
So we might not be able to get you on treason, but we'll get you on for some. Don't you worry about it.
Well, in 1896, in the Jim Crow era, Justice John Marshall Harlan was the lone dissenting vote in Plessy versus Ferguson in 1896, which declared racial segregation constitutional and created the concept of separate but equal.
Yeah.
In his dissent, Harlan wrote that the majority's opinion would prove to be quite as pernicious as the decision made by his tribunal in the Dred Scott case. Charles Evans Hughes writes in 1927 on the Supreme Court's history, described Dred Scott as a self-inflicted wound from which the court would not recover for many years. Well, they had to follow the law, man. So you can change the law, you got to follow it. Sorry.
No, it's how they interpret the law.
That's true.
They could have interpreted it differently.
That's very true as well.
1952, as a law clerk to Justice Robert H. Jackson, future Chief Justice William Rehnquist, he wrote in a memo on Brown versus Board of Education. Scott versus Sandford was the result of Taney's effort to protect slaveholders from legislative interference. Okay. Dissenting from Planned Parenthood versus Casey in 1992, insofar as it was upheld to the right to abortion established by Roe v. Wade 1973, Justice Antonin Scalia compared the rationale behind Planned Parenthood versus Casey to Dred Scott. Since Dred Scott rested upon the concept of substantive due process that the court praises and employs today. Indeed, Dred Scott was very possibly the first application of substantive due process in the Supreme Court.
Right.
The original precedent for Roe v. Wade.
Justice Clarence Thomas similarly compared Roe versus Wade to Dred Scott in his concurring opinion in Dobbs versus Jackson Women's Health Organization, the decision overturning Roe versus Wade in 2022. Chief Justice John Roberts compared Obergefell versus Hodges in 2015 to Dred Scott as another example of trying to settle a contentious issue through a ruling that went beyond the scope of the Constitution. Historian Sean Willents, he called Trump versus United States, the 2024 Supreme Court decision that conferred immunity from criminal prosecution as a president's official acts, the Dred Scott of our time, he said.
Oh, piss out, crybaby.
Right. Other writers made the same comparison.
Yeah, but they did. Jeez. Let's take a look at the legacy of this. 1977, the Scott's great-grandson, John Madison Jr., an attorney, he gave the invocation at the ceremony at the Old Courthouse in St. Louis, which is a National Historic Landmark, for the dedication of a National Historic Marker commemorating the Scott's case that was tried there. Year 2000, Harriet and Dred Scott's petition papers and their freedom suit, they were displayed at the main branch of the St. Louis Public Library, following the discovery of more than 300 freedom suits in the archives of the U.S. Circuit Court. Oh.
Right. 2006, historic plaque erected at the Old Courthouse to honor the active roles of both Dred and Harriet Scott and their freedom suit and the case's significance in United States history.
How do you erect a plaque?
Right. 2012, huh?
How do you erect a plaque?
Right. 2012.
You just hung it.
A monument depicting Dred and Harriet Scott was erected at the Old Courthouse's east entrance facing the St. Louis Gateway Arch.
Oh.
And the year 2024, during the 2024 presidential election, the National Federation of Republican Assemblies cited Dred Scott versus Sandford to claim that Vice President Kamala Harris is not a natural-born United States citizen and therefore is ineligible to run for president. That's fucking stupid.
Yeah, that was a pretty doozy of a case there, huh?
Yeah.
Craziness.
Rough.
The old Constitution of the United States decided that. Well, even for after all that, for him just to go free.
Right.
Anyways, all the backlash, all the lashback. Yeah, it's Dred Scott versus Sandford. Historic decision, and like I said, people call it the worst decision in Supreme Court history. Could have been. How do you decide that somebody's not human?
Right.
Basically.
It's rough.
I mean, it's crazy, dude. Crazy. But yeah, that's it for that. Next week, we'll bring it back to probably some more profiling, just like the Supreme Court did here.
All right.
Profiling, probably with, it's going to be another union guy. Maybe Burnside, somebody like that. I don't know. Sheridan. Sherman, one of those guys. Either or, we're back for more Behind the Battles. So we'll see you next week for Battles of the American Civil War. We are the Mother Music Industry.